There was another case in which an application for bail was made of a person who was in detention awaiting his extradition to a foreign country. Now, bails in extradition matters have to be very rarely granted, very rarely, because the fugitive offender has fled the state where he's required, he's in another state, so if he is granted bail, the likelihood of him absconding is there. But that doesn't mean that the grant of bail is an absolute no-no. The conditions on which the bail can be granted has to be made so stringent so as to ensure that he is going to be present in the proceedings. And one such case came before me where a request had been made by the United States of a person who had been charged with a fraud of $30 million in the Medicare scheme. He was in Pakistan. The inquiry magistrate had recommended his extradition, which had been approved by the federal government. His judicial review had failed, but he was awaiting his extradition in Pakistan, but he could not be kept in jail indefinitely. And the requesting state said that by reason of the COVID-19 pandemic, we are in no position to take him. In such a situation, the Court of Constitutional Causes steps in and grants bail. But the conditions on which the bail is granted have to be very stringent. So a very unusual form of a security was asked to be presented. He was restrained from going out of the jurisdiction of the Islamabad Capital Territory and was required to report to the Additional Registrar Judicial of the Islamabad High Court every 2 weeks. This was just to ensure that he does not flee. Ultimately, when the requesting state was in a position to take him, he requested not to be arrested on the undertaking that he would report at the airport where he was to be taken by the requesting state. We gave him the benefit of the doubt and did not order for his arrest. He boarded the plane and went abroad. And apparently, in the requesting state, he's out on bail. So each and every case has its own particularities and have to be dealt with great care and caution. Thank you very much for that introduction. Ladies and gentlemen, Assalamu alaikum. I deem it a privilege to be invited to speak on the subject of extradition. As a legal practitioner, I didn't have an opportunity to deal with any case of extradition, but sitting in an adjudicating capacity, I got an opportunity to judicially review the decisions that had been made or recommendations by the inquiry magistrate to the federal government whether or not to extradite a fugitive offender who had been wanted by either a treaty state or a state with which Pakistan does not have an extradition treaty, either to serve a sentence because he'd been convicted or to face prosecution. It was a cumbersome task in the sense that in exercise of our powers of judicial review under Article 199 of the Constitution, you do not hear the case like an appeal. Your parameters are restricted when you examine the matter. It is essentially in the nature of a high prerogative writ, a writ of certiorari that we adjudicate upon. And in doing so, we only have to examine as to whether there had been a jurisdictional irregularity in the procedure that had been adopted by the inquiry magistrate in making a recommendation. I must take this opportunity to say that the recommendations made by the inquiry magistrate in at least a few of the cases that came before me for judicial review left much to be desired. That is not because of the inability of the inquiry magistrate, I mustn't be misunderstood, but because he didn't happen to be a person well-versed in law. He was not a judicial magistrate. He was an executive magistrate. He was not a full-time executive magistrate dealing with cases of extradition. The responsibilities as an inquiry magistrate were in addition to several of his other duties as a civil servant. The extradition law, as we have it prevalent in Pakistan, requires, by its very nature, for the executive magistrate to be well versed in the scriptures of law. He has to exercise the powers of a sessions court. Can you imagine a responsibility being given of a sessions court to a person who is not a qualified lawyer? In deciding whether or not to grant bail, he has to understand the provisions of the Code of Criminal Procedure. You can't educate him first and then tell him to sit in these very complex matters. Extradition law has to be very strictly construed. The court has to ensure that a person's fundamental rights are protected. And this is the primary responsibility of a court of constitutional causes. And therefore, the procedure that is applied ought to be very strictly construed. It is interesting that the British High Commission, in collaboration with our Ministry of Interior, has arranged for this handbook, which is going to come in very handy, not just for the inquiry magistrate, but for the legal practitioners. But it is also ironical that we do not have an extradition treaty with the United Kingdom. That, however, does not mean that the provisions of our Extradition Act cannot be made applicable for the extradition of a fugitive offender with a country or a state with which we do not have an extradition treaty. I recall some years ago, we dealt with a case where a request had been made by the United Kingdom for the extradition of a person who had been charged and convicted of the offense of murdering 8 people in Huddersfield. It took the authorities 10 years to arrest him here in Pakistan, and he had been brought before the inquiry magistrate. Now, what happens where the requesting state does not have a treaty, extradition treaty with Pakistan? Our extradition law provides a solution for it. That the particular offense that a person is required for, either to be prosecuted or if convicted to serve a sentence in the requesting state, a notification is issued by the federal government under Section 4 of the Act, making the provisions of the Extradition Act applicable to that particular request. The machinery of the Extradition Act will become applicable only once such notification is issued. So, the inquiry magistrate for that particular extradition request cannot be appointed, and an arrest cannot be made until a notification under Section 4 is issued. And therefore, the Islamabad High Court had to declare that the arrest made of a fugitive offender prior to the issuance of the notification under Section 4, which makes the provisions of the Extradition Act applicable to a particular request, was without lawful authority. Ultimately, the extradition request was allowed, the judicial review failed, and the fugitive offender was extradited to the United Kingdom, and I believe he's now serving a sentence over there. Extradition requests have to be taken extremely seriously. And as I said, the strict construction of the law requires complete satisfaction in the mind of the inquiry magistrate that not just will the requesting state, after the fugitive offender is extradited, subject him to a fair trial, but the conditions in his country where he's going to be lodged, either in prison or in another confinement facility, are such as to extend him all the requirements of human rights. This is a reciprocal obligation. The reason why requests made by Pakistan to countries like United Kingdom are not successful is because in the United Kingdom there is the European Convention of Human Rights, which requires that when a person is detained, his detention has to be of a certain standard. The room that he is confined in has to have a certain measurement. Exercise, food, interaction, recreation. When they realize that these facilities are not available in prisons in Pakistan, a question of extradition will not arise, no matter how meritorious the case is. So therefore, we have to ensure that where extradition requests are made, there is an assurance given by the government that the fugitive offender in Pakistan would be given the same very facilities as would such an offender be given in the United Kingdom. There are examples where assurances are given by the state that penalties such as the death penalty would not be implemented. Now, the law does not provide for any obligation for the court not to extend the death penalty in a particular case. And the courts are not bound by decisions that are made by the executive. But in such situations, even where the death penalty is pronounced by a court of competent jurisdiction, it is the responsibility of the state to execute it. And there the state can give an undertaking that if such a penalty is pronounced, that it will not be undertaken. There was another case in which an application for bail was made of a person who was in detention awaiting his extradition to a foreign country. Now, bails in extradition matters have to be very rarely granted, very rarely, because the fugitive offender has fled the state where he's required, he's in another state, so if he is granted bail, the likelihood of him absconding is there. But that doesn't mean that the grant of bail is an absolute no-no. The conditions on which the bail can be granted has to be made so stringent so as to ensure that he is going to be present in the proceedings. And one such case came before me where a request had been made by the United States of a person who had been charged with a fraud of $30 million in the Medicare scheme. He was in Pakistan. The inquiry magistrate had recommended his extradition, which had been approved by the federal government. His judicial review had failed, but he was awaiting his extradition in Pakistan, but he could not be kept in jail indefinitely. And the requesting state said that by reason of the COVID-19 pandemic, we are in no position to take him. In such a situation, the Court of Constitutional Causes steps in and grants bail. But the conditions on which the bail is granted have to be very stringent. So, a very unusual form of a security was asked to be presented. He was restrained from going out of the jurisdiction of the Islamabad Capital Territory and was required to report to the Additional Registrar Judicial of the Islamabad High Court every 2 weeks. This was just to ensure that he does not flee. Ultimately, when the requesting state was in a position to take him, he requested not to be arrested on the undertaking that he would report at the airport where he was to be taken by the requesting state. We gave him the benefit of the doubt and did not order for his arrest. He boarded the plane and went abroad. And apparently, in the requesting state, he's out on bail. So, each and every case has its own particularities and have to be dealt with great care and caution. There was another case in which the learned judge in chambers of the Islamabad High Court had ordered that for every extradition case, the requesting state has to bring its inquiry officer to Pakistan to subject him to the test of cross-examination. The division bench of the Islamabad High Court had to interfere with it because there was no such sanction in the law. It's all the documents that have to speak. And the documents that are presented and the statements along with the documents have to make out a prima facie case. A case which is there to answer. It is just like in England there are committal proceedings committed by the magistrate in order to see as to whether the matter should be referred to the Crown Court for a trial. So you do not have to establish guilt beyond reasonable doubt in extradition proceedings. All you have to do on the basis of the record is to see as to whether there's a prima facie case for the requesting state for a trial to be undertaken in that country. Now, in order to determine as to whether there's a prima facie case, the inquiry magistrate has to have some judicial experience. He has to be well versed in law, because there's a very thin dividing line. When he sits and exercises the powers of a session court, he has to be familiar with the requirements of the Evidence Act. I say so because recommendations for extradition have been interfered with by constitutional courts on the ground that hearsay evidence was taken into consideration in allowing a request for extradition. So the inquiry magistrate has to know the difference between the different standards of evidence that is produced. There was recently another case in which a fugitive offender was wanted by the United States of America for conspiring to commit acts of terrorism. The evidence that was produced was entirely hearsay, but we are living now in different times. Today's criminal is computer literate. There are many new offenses that have been created. So therefore, the mere fact that the evidence was hearsay in nature would not necessarily result in the discharge of the person whose extradition was sought, but in that case, you would give an opportunity to the requesting state to bring in direct evidence. Now, direct evidence can be produced without disclosure of the person or his identity, because terrorism is an offense of a heinous nature. We do not want our investigating officers or the police to be identified for fear of reprisals. This may cast a shadow on the veracity of their statements also. So this was a way out that was given to the inquiry magistrate, and where if he feels that it is a matter of utmost importance for the inquiry magistrate to come and give direct evidence, he can order so. But it would be in cases of exceptional nature, where a decision could not be taken unless such evidence is given. I can go on and on about this, but I ought to constrain myself and congratulate the Ministry of Interior as well as the British High Commission for bringing in this handbook. It will not just serve as a guide for inquiry magistrates, but also for constitutional causes. I would urge you not to just distribute it to the Islamabad High Court, but also all the other high courts. Thank you once again. Thank you.